Hi guys, it's Kathy. I hope you're doing well. Yeah, Windows decided to force an update on me that I couldn't click out of today. And it shut everything down. And I had to restart everything. But that's okay. It's Sunday. It's a lazy Sunday. We're fine. I gotta work today, but hopefully everybody else has off. And nobody else has to work today. So, this coming week, I know I said I wasn't going to have any content and it was going to be sketchy. However, I'm going to replay something I played about 2 years ago, maybe a year ago, on the live stream. That is the same judge that we're watching today. And it's really good. It's really good. So I can't wait. Hi, Jamie. All right. Yesterday, we had him talking for an awful long time. Today, oh wait, there we go. Hold on, I want to fast forward it one more minute. Nope, too far. Oh man. Today we start with her. Hopefully she gives us more detail and this is just a bit better. I've never had a problem with the Georgia prosecution. I like the Georgia prosecution. They do a good job. Hey, Lazzie. So, here we go. Let's go.
Mr. Smith, excuse me, Ms. McStanley. Mr. Smith, I'm gonna ask you to unplug your laptop, because if you hadn't already, oh, she already has, okay.
Yes.
Go ahead.
13 times. That's the number of times that Napoleon Flowers shot an unarmed man, shot in the direction of Tanya Driver and Jermaine Deckard, and at a house that a 15-year-old boy was inside of. Now, you heard Napoleon Flowers say in his interview, the only thing he thought he did too wrong that day was flee the scene and go to Cochran. Was it not wrong that you shot at an unarmed man 13 times? And you even heard Napoleon tell you, he said he knew that he shot 13 times because that's how many bullets he had in his gun, and he shot every one of them. Now, the defense has told you several times, sticks and stones may break my bones, but words will never hurt me. Well, words were all that Jim Mack Johnson had because he sure didn't have a shotgun. There is no evidence that he had a shotgun. Now, at the very beginning of this trial, in the opening statements, I told you that 2 days before Mother's Day, Napoleon Flowers told Tanya Driver that he would shoot her, pop Jim, and go ghost. And that's exactly what he set out to do on that Mother's Day. But just the day before, on that Friday, May the 12th, his cousin, Mariah Flowers, who you saw on the stand, she would call him. And she would tell him that something happened between her and the neighbors. And then what happened? Later that night, she went to get him. And he come to his grandma's house. He stayed there, and until Mother's Day when this happened. Napoleon was looking to get into a confrontation with the neighbors. That was also evident in the 911 call that you've now heard several times made by Tanya Driver. You heard Tanya telling the 911 operator that Napoleon had a gun before you even heard the shots. She called them as soon as she saw that impression in the hoodie pocket of his jacket. She called them to get help, but you heard how fast all of that happened. Jermaine Deckard even told you how fast it happened. He said he was in between two people. He was right here with Jim and Napoleon was across from him. And he was looking back and forth, and by the time he looked back, Napoleon pulled out a gun and he started shooting. And Jermaine told you, as soon as that first shot fired, I took off. I ran. Everybody at that house that day took the stand and told you we were afraid for our life. And Tanya specifically said, I thought I was dead. That's what she told y'all. Now, Napoleon told you in his interview with Agent Reese that he did this because he thought he saw Jim with a gun and he was trying to defend himself and his family. But he left his entire family and his girlfriend at the house as he jumped in the car for his cousin to haul him away to Courtroom, not even knowing that this imaginary threat had been shot. If you are trying to protect yourself and your family, and he said, I didn't know that I had shot the guy, why would you get in the car and leave? All of them at the house. Now, if we go back to the very beginning of this trial, and I know that's a long time ago, but the first witness that you heard from was Officer Nick Hewlett. He is the witness that you saw the body cam played through. And you were able to see Jim Johnson lying on the floor. He was bleeding out, and he had fallen as soon as he had gotten in the back door of Tanya's house. And then you heard Tanya take the stand. And she
I'm glad we didn't see that.
This is one of the most traumatic events that she has ever experienced. And it was. She told you about the issues that she had with Napoleon, making threatening comments just 2 days prior. You heard her frantic on that 911 call, running around. As she was on the phone with them, she ran to avoid getting hit by the rain of bullets that Napoleon was firing from that gun. She saw her boyfriend on the floor, lying, bleeding out of his head. And she specifically said she was trying to make sure that Napoleon didn't come back and finish the job. Now, Tanya also tells you that she heard the bullets coming by her and she thought that she had been shot. You heard her on the 911 call say, I must have been grazed. My foot got grazed. Something's grazed. You heard Jermaine tell you that he heard the bullets coming by him too, and he was running away, trying his best not to get hit. Now, Tanya's son, Xavier, told you that he was in the house, he was playing a video game, and he heard the last couple of shots that were going off. And at that point, he jumps up, he gets a gun, he runs out into the hallway. His mama would later tell him to put that gun up, and Jermaine would take it and he would put it on the bed. When Tanya said, put it up, she told you, she explained what she meant. She told him it's over. It's over. And he saw that Jim was already in the floor, bleeding out. So that is why she told him to put the gun up. It was too late at that point. And you also heard Xavier tell you that he was scared, he was emotional, And he saw a man lose his life that day. And he did. He
Kelly,
saw Jim lose
Monica,
his life
Kelly,
that day.
thanks for the cheers.
Now,
I appreciate
Tanya
it.
also told you.
Hey, Jude. Love. If you don't want to type out everybody's name, you don't have to. You can just come in and say, hi, y'all. It'll make it easier. I know it's terribly difficult to type out every single name.
That the day before, on May the 13th, Mariah Flowers pulled into their driveway, began cussing at them, threatening them. It wasn't the other way around. Then you heard from Justice Roberts, Napoleon's cousin. He told you that he didn't see Jim Johnson with a gun. He told you that Napoleon
What language is
asked
that,
him to take
Maria?
his chakra, and that he
I don't
saw
understand.
Napoleon put a gun in his
Chocolate-free
book bag
cookies.
when he got in the car.
Must be French or something.
You also heard from Officer William Cooley. That is who conducted the traffic stop on the car that Justice and Napoleon was in. He collected the weapons. And you also heard from Josh Robertson, who is the investigator at the Eastern Police Department, who stayed on scene with GBI and helped them. Now, another witness that you heard from was the GBI crime scene specialist, Leah Chambers. She told you that she collected Napoleon's cartridge casings in the grass area in front of Pam Flowers' carport. And she told you, and we showed you on one of the larger images of the house, that the bullets were directly across toward the edge of the house, and that the bullet defects on the house were penetrating. Now, the defense wanted to talk about how she did not put a rod through the bullet holes and try to see what the flight path was. But Agent Chambers told you that those bullet defects were penetrating, which means that the bullets went in the wall, but she couldn't recover them and get them out of the wall. And that's why she told you that she did not put rods in to try to do a flight path. Now, she also told you, most importantly, that the location of those cartridge casings in the grass indicated movement. Movement as in walking or moving the body. And that's important because we know that Napoleon told us in his interview, I stepped off the cement from the carport and into the grass. That was toward Jim Johnson. That's why that's important. Now, Agent Chambers, I asked her, did she see a gun outside? She didn't see a gun outside. I asked her, were there any other cartridge casings, spent shells collected, other than those 9mm shells that Napoleon had? And she said, no, I didn't find any other ones. So that tells you that another gun was not fired. And that another gun was not outside. There was never one located. Now, you heard from both Mariah Flowers and Michaela Gert. Neither one of those witnesses saw Jim Mack Johnson with a gun. And one important thing is, Michaela got up here and even testified that she didn't think it was the best thing for him to leave. In fact, she said, if he was defending himself, he should have stayed until everybody got there. And he didn't do it. He got in the car and he was trying to get to Cochran. Now, the last witness that you heard from the state was Agent Reese, seated right here at the table with us during this whole trial. And through his testimony, you heard the interview that he did with Napoleon. And you heard a lot of things from Napoleon, most of which didn't make any sense. Napoleon told Agent Reese at first that he saw a shotgun. That's the first thing he told him. And he told him that he saw Jim put his hands physically on that shotgun. But later he would go on to say that Jim never raised the shotgun. He never raised it up. He never pointed it. He never fired it. Finally, Napoleon would tell you towards the end of his interview, well, it probably was just a BB gun because the butt of the gun, the stock of it, wasn't big enough to be a shotgun. But during that interview, if you also recall, and remember back to the beginning of it, when Agent Reese asked him, did he lift the shotgun up, did he raise it, point it? Napoleon said, it didn't even get that far. And he admits that he shot 13 times because that's all the bullets that he had in his extended magazine. And he mentions that he continued to shoot at this unarmed man and in the direction of 2 more people and a child in the house as Jim turns his back to him. He even continues to shoot as he tells you that Jim is taking some steps back into the house through the back door. Now I want you to think about that. Think about Jim taking some steps into the back door of the house. And think about what Dr. Sandra Reynolds, the medical examiner, said. She said, with the type of injury that Jim had, which was a single gunshot wound to the top of the head, that he could very well have taken a couple of more steps. And those couple of more steps was him trying to get in that back door, trying to get to safety, but he got shot. He took those steps, and he fell right there in that doorway. And I also want you to recall back to the body cam of Officer Hewlett, where you saw his body lying. That was right there in the doorway. His feet was at the door, and his head was in the carport area towards the other door that you went into to go inside the house. And I also want you to think about Napoleon's comment where he said that he took a step off of that little cement carport over the little line of brick pavers and onto the grass. Napoleon tells you that Jim and them are right there at the edge of Tanya's house. If he took a step, you saw the pictures, if he took a step off of the cement part of the carport over the pavers and into the grass, he's going toward Jim. Why would you go toward somebody who has a shotgun? You wouldn't. You just wouldn't do it. Now, another really, really important thing to me that Napoleon says to Agent Reese is that he took those steps into the grass because he knew shells were going to fly. That tells you he knew what he was about to do. And he was getting out into the grass to start shooting at where Jim, Jermaine, and Tommy was located. And the last thing Agent Reese talked to you about, or one of the last things, was the cell phone being in Jim's hand. And Agent Reese told you that was something that was really important to him because Jim could not have been holding a shotgun and trying to operate it with a cell phone, a flip phone, in his hand. Now, I will tell you, at trial, I usually use what I call the puzzle example with my juries. And with that example, I would have told you that you have to look at the evidence in a case as different little pieces to a puzzle, a jigsaw puzzle. And that at the end of the trial, after the evidence is closed and you've heard everything, that you have to put all those pieces of evidence together to see what the picture of that jigsaw puzzle is. And let's just say it's a jigsaw puzzle of a beach scene. At the end of trial, you might have enough pieces to see the sand, to see the water of the ocean, to see the palm trees, but you might be missing a couple of pieces. And you might not be able to see the little umbrella chairs that are on the beach. You might not have the full picture. But I can't use that example here because you already have the full picture. You have every piece to the puzzle. And so you know exactly what happened here through the evidence that was presented in this case. The pieces to your puzzle are already complete. And I'll go through them. Piece number 1. Tanya Driver, Jermaine Decker, Justice Robinson, Mariah Flowers, Michaela Gertman. None of those people ever saw Jim Johnson with a gun. Number 2, the second piece. Napoleon is the only person who sees the victim with a gun, but his explanation about this purported gun that he saw in Jim's hands, it evolved, it changed, it didn't stay the same. He changed that. He went from a shotgun to a BB gun to the stock of it wasn't big enough for a shotgun, it had to be a BB gun. You know, piece number 3 to the puzzle, Napoleon showed Tanya the impression of his gun through his hoodie pocket. She called 911, you heard that, and then you heard all those shots after she had got on the phone. Now, piece number 4, you have 2 eyewitnesses to this shooting, Jermaine Decker and Tanya Driver. And number 5, you know that Jim turns his back at some point and starts trying to get back in his house, but that Napoleon keeps shooting because he tells you that. Number 6, you even know the number of times that he shot the gun because he tells you that. Number 7, Napoleon jumps in the car. He tries to leave and get away to Courtroom. And number 8, the last piece. This is the middle piece of the puzzle that completes the whole picture. Napoleon told you that he knew shell casings were going to fly. He knew what he was going to do. When he went outside that day and he got in that back and forth argument with Jim Johnson, he knew what he was going to do. Jim never had a shotgun. He never pulled one on him. He never asked Tanya to go get one. Tanya never gave him one. Napoleon knew that he was about to start firing shots. This picture that has been put together by these different pieces of evidence shows you one thing and one thing only. That Napoleon gunned down an unarmed man as he was running back in his house. He shot at him knowing and seeing 2 people right there in his area of where he was standing and who felt bullets fly past him. He shot toward a house that a child was in, and he fled the scene. A reasonable person would not believe that use of force was necessary. Now, I want to go into briefly a couple of points that the defense has brought up. The defense brought up these continued issues, these continued feuds between Tanya Driver and between the Flowers next door, and he talked about how it was just continued issues all the time. And there's one thing that's for sure. There's one thing that's not in dispute. There were continued issues between those 2 households. I think that's obvious and apparent to everybody. But the defense told you and harped on these incidents between these 2 households for one reason. And that one reason was to distract you. And the best way that I can explain it is this way. Imagine getting in your car to go to work or to drop your kids off at school one morning. And you get in the car and you get on the highway, and you can't see very far on the highway because there's a bunch of fog. You have to turn your headlights on, you have to be careful, and you have to really look where you're going to see the road. That is what all of this back and forth between the families is. But what you have to do is you have to look ahead. You have to look at the bigger picture, look at the road ahead. And the road ahead shows you that the evidence from May the 14th on Mother's Day was that Jim didn't have a gun. He never did. And Napoleon gunned him down shooting 13 times. That is the bigger picture. Now, one other point that the defense made to you was that on that Friday, that May the 12th of 2023, supposedly Napoleon was never at that house. He was never at Grandma's to tell Tanya and Jim that he was going to shoot them in the face, pop Jim, and go. But remember when Pam Flowers took the stand? And remember when I asked her, on May the 12th, were you working? Yes, I was. What was your hours? Well, it was like 4:30 a.m. until 6 o'clock in the evening. And she said, well, I came home, a couple of times throughout the day. And that's possible. She may have come home a couple of times throughout the day. But think about all those hours that she was at work and not at the house. She couldn't have known if Napoleon was there or not.
She couldn't have known. So, I wonder what it's like to start work at 4:30 a.m. every day. That must be crazy. I have to pause for a second. Jude. And Kelly. It looks like Kelly too. Yesterday, I opened up my Discord and I found 2 songs written by Jude. And I love them, Jude. I love them to the moon and back. They were so funny. It was about my neighbor. I called a mean old lady, right? However, I can't play them, Jude. I can't play them. And here's why I can't play them right now. I can play them in a couple months, I think. But I can't play them right now because on the second song, which is the best song, it's so good, it would be misunderstood in this current. So, I know you're talking about my neighbor. You know you're talking about my neighbor, right? But in that second song, it says how I got locked up for something I said. So recently, unfortunately, we lost some vibers because of something I said. So if I play that right now, it will look like I wrote a whole song just to poke at them, the people that left because of something I said. And we both know that it has absolutely nothing to do with them whatsoever. But the wording is perfect. You don't know how perfect that wording is for the current environment in some of the drama behind the scenes, Court 5s. So here's what I'm going to do. I'm just going to wait a couple months, and then I'm going to play those 2 songs because they are amazing and they made me laugh. And thank you. Thank you, Jude. Thank you so much. It's funny how you got those words in that order. It would stir up so much problems if I played them right now. And I know it's the 2 songs. It's the one where you said that I was put in jail because of something I said because they didn't agree with my words, my opinions. Oh, it was great. You have no idea. You are psychic.
She wasn't there the whole day to know whether or not he'd come by. Now, another thing that I want to bring up is when Pam Flowers took the stand, she talked about that incident on May the 13th, the day before the shooting, where all of this issues apparently happened between Mariah Flowers and Jim and Tanya next door. Well, I asked Pam several times, are you sure that Mariah was not backed into the driveway? Yes, I'm sure. And I said, are you sure that Johnson tried to snatch Mariah's passenger door handle? I'm sure. I saw it. I said, are you sure that he came to the passenger side of the car? I'm sure. But think back when Mariah took the stand. She said she backed into the driveway at her grandma's house. And she told you that because she was backed into the driveway, Tanya's house would have been over here. So her driver's side door would be here. But Jim come across the yard towards her vehicle on the driver's side. And that before he even got to the car, she already had the door open to get out in front of him. That is not what Pam Flowers told you. Those two stories are not adding up. And I submit to you they are not adding up because that's not what happened. Just like Tanya said, Mariah went to Tanya's house, threatened to beat her up, and that's what's happened. The police was called after that. Now, another point that I want...
So these neighbors have been fighting for a while. And on this day, two of the neighbors said they were going to get a shotgun because they were just mad. So I should move myself and right in Napoleon's way. This right here that I moved myself down to, those two women are the deceased family. So they're very sad. I know this because when the prosecutor started saying, when the defense attorney started his stuff, they started crying hard. But this guy, you cannot see my mouse. Okay, so the guy way on the left that I just moved my face away from, with the hair up here, he was fighting with two of his neighbors, and the two neighbors said they were going to go get a shotgun to shoot him. So they left, and then when they were coming back out of the house, he shot them 13 times. And then one of them died. One of them was a clean headshot. So he has 13 counts against him right now. Not one, I think that might be a coincidence for the number of bullets. I think they're different counts, and I'll tell you why. You'll find out why when we hear the verdict. Why not all these counts are the same. And the verdict is crazy. I can't wait. We're so close.
To make is that Pam also said, when Mr. Smith was questioning her, that Justice Robinson wasn't parked in the driveway and she didn't see the car. But she told you when I went out the front door, I saw Napoleon run by. Well, we know the car hadn't left yet because Napoleon had to get in the car to leave. We saw him pulled over in the car. Well, she says that Justice's car wasn't in the driveway, but think about this. Justice told us that he was seated on the steps under the carport, and he immediately to his left side would have been the blue car that you saw. And I asked Justice, I said, okay, as soon as the shots went off, what did you do? I ran to my car immediately. And I said, how long did it take you to get there? Oh, well, I was pulled right up in the driveway. It took me a few steps and I was in the car. It's not what Pam said. So again, we have two discrepancies in that testimony. And so Pam also says that she saw the car leave because she saw Michaela going out to the car, and she said, get back in the house. Don't go. So she saw the car, but where her and where Justice are saying it was located is two totally different places. Now, another point that I want to make is this Kayla Davidson person. Both Pam and Mariah and Kylie Flowers are all saying that this Kayla Davidson pulled up in Tanya's yard before the police even got there. But remember what one of the first questions I asked Officer Nick Hewlett was. I said, how quick were you to the crime scene after you got the call out? And keep in mind, he had already been dispatched because Tanya called early and said, well, look, there's Napoleon's out here and he's got a gun. So she's already on the phone with 911. Nick Hewlett's already been dispatched. He told you he got to that house pretty quick. Well, then you hear the shots in the background. You see Nick Hewlett get to the house. He doesn't even have to open the door because Jermaine Decker and Tanya Driver are standing right there, and Jermaine's saying, he's in there, he's in there. And Nick walks out and sees him. And he even told you that Jim had adrenals. He was still breathing a little bit when he got there. And that's because it had happened so quick. It had just happened. So how is it that this Kayla Davidson pulled up so fast before Nick Hewlett even got there, when Tanya was already on the phone with 911? They had already been dispatched that quick. And the other major issue with this Kayla Davidson is this. Not a single solitary person ever mentions it. And I asked Pam, I asked Mariah, I asked Kylie, did y'all tell Eastman Police Department? No. Did y'all tell the GBI agent that you talked to? No. Well, why not? Did you think it was important? No, not at the time. But you think it is now? Yeah. Well, why didn't you call? I don't know. It's because it didn't happen. It didn't happen. Kayla was never at that house before police got there. Now later on, through the testimony, you would hear that she came and picked up Xavier because he was so upset, and I think Agent Reese was actually the one who told you that he was told that the child was having some breathing issues, and that's part of the reason why they got him away from the house. He didn't want to push the issue. He was so upset and interviewed him that day, so he come back and done it at a later time. Now, I am going to go into my PowerPoint from here. We went through the witnesses, we went through the testimony, so let's get into the PowerPoint. So let's look at what is
Lady, speak up. I'm old.
What's in the state's indictment is malice murder, felony murder, 4 counts of aggravated assault. You got 1 for shooting at Jim Johnson, 1 for shooting in the direction or the vicinity of Tanya Driver, 1 for shooting in the vicinity of Jermaine Decker, and 1 for shooting at the house that the child was located.
Hold on. We gotta hear that again. We gotta hear that again. I didn't hear it all, and it's so low. And these are the charges, I think, right? So we were at 21-14-54. If we just go back to 21-14, I wonder if I can just type it in. No, I can't. Okay. 21-14-14. That's good enough. We'll get to hear some of the charges. Now pay attention just to this part.
That day, so he come back and done it at a later time. Now, I am going to go into my PowerPoint from here. We went through the witnesses, we went through the testimony, so let's get into the PowerPoint. So let's look at what is in the state's indictment. And what's in the state's indictment is malice murder, felony murder, 4 counts of aggravated assault. You got 1 for shooting at Jim Johnson, 1 for shooting in the direction or the vicinity of Tanya Driver, 1 for shooting in the vicinity of Jermaine Decker, and 1 for shooting at the house that the child was located inside of. You've got a count of aggravated battery, a count of cruelty to children in the first degree, and a count of possession of a firearm during the commission of a felony, times 5. You got 5 counts of that. So let's go through them and apply. Let's do this first. So the standard that the state has to prove, and that the defendant.
You don't have to memorize the charges. You do not have to memorize the charges to keep up with the crazy verdict. You don't. It just helps a little bit. Not to memorize them, just to get a general understanding.
It's told you I have to prove is we have to prove each and every offense alleged beyond a reasonable doubt. And I know that the defense went back and forth trying to explain to you what is a reasonable doubt. It's hard to understand. Here's some examples. But it's actually not that hard to understand. A reasonable doubt is not to a mathematical certainty. It's not beyond all doubt. It's not beyond a shadow of a doubt. It's just as it sounds. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. That's all it is. Now let's go ahead and go through the charges. Malice murder, that's count number 1. So malice murder means that a person commits the offense of murder when they unlawfully and with malice aforethought, either express or implied, cause the death of another human being. Express malice is a deliberate intention unlawfully to take the life of another human, which is manifested by external circumstances capable of proof. And malice shall be implied where no considerable provocation appears and where all the circumstances of the killing show an abandoned and malignant heart. And the judge is going to instruct you about the law, so you'll hear it again. You don't have to worry about that. The judge is going to instruct you. But let's look at the facts that we have in this case to prove malice murder beyond a reasonable doubt. Napoleon showed Tanya the impression of his gun through his hoodie pocket. He took his gun out, he cocked it, and he fired it 13 times. That's what Jermaine said. He continued to shoot as the victims were running away. He shot when Jim Johnson turned his back to him. He knew shell casings were going to fly. Let's go to felony murder. Now, felony murder is not quite as complicated as you can see by the list stuff that I have on the screen. So a person commits the offense of murder when, in the commission of a felony, he or she causes the death of another human being, irrespective of malice. So with felony murder, you don't have to have malice. So you have to cause the death of another, and it has to be during the commission of the felony. Well, here it's during the commission of the aggravated assault, shooting at Jim Johnson. And the judge is going to instruct you on the definition of what a felony will be, and he's going to instruct you that aggravated assault is in fact a felony. So we had 4 counts of aggravated assault. Now, a person commits the offense of aggravated assault when he or she assaults with a deadly weapon, which when used offensively against the person is likely to or actually does result in serious bodily injury. Napoleon shot Jim Johnson in the head with a firearm. We know that resulted in serious bodily injury. Napoleon shot in the vicinity of Tanya Driver with the same gun. That's count 2 of aggravated assault. The third count, Napoleon shot in the vicinity of Jermaine Deckard with a firearm. And the last count of aggravated assault, Napoleon shot towards the residence in which Xavier Young was located. Now, aggravated battery. A person commits the offense of aggravated battery when he or she maliciously causes bodily harm to another by depriving that person of a member of their body, or by rendering a member of their body useless, or by seriously disfiguring the body or member thereof. Now, Napoleon maliciously caused bodily harm to Jim Johnson by depriving him of his brain, which is a member of his body, by shooting him in the head. And I want you to think back specifically to Dr. Reynolds' testimony. And I asked her, would this sort of injury debilitate somebody? Yes, it would. And then think back to something that Agent Reese told you, which was they had to fly Jim out. And I said, well, what does that mean? Well, he had to be taken to a different hospital, put on a ventilator, where he ended up passing away a couple of days later.
That's Jim's family, maybe sister, wife,
Any person who
mom.
commits an offense of cruelty to children in the first degree, when that person maliciously causes a child under the age of 18 cruel and excessive physical or mental pain. Here we have it charged as mental pain. So, Xavier Young suffered cruel and excessive mental pain. He told you that the shooting scared him such that it caused him to go grab a gun. He told you it had an emotional impact on him, and he also told you that he saw someone's life taken away that day. Now we have these counts of possession of a firearm during the commission of a felony. So any person who shall have on or within arm's reach of their person a firearm during the commission of any crime against or involving the person or another.
So I looked up Dodge County in Georgia. I don't have the specific statistics for Dodge County's crime rate. They weren't readily available, and I didn't feel like digging further. But Georgia overall has a lot of murder. I mean, but not so much Atlanta. That has drastically dropped. The murders in Atlanta, way down. Fulton County, on the other hand, holy cow. So, I looked up Dodge. I was able to see a map, an interactive map of just crime in Dodge. And it is like night and day. So there's this green part, and like 2 streets separate this bright red section. So if you live in the green part, crime rate is graded at A. But if you live just 2 streets away, it's bright red. It's bad. It's a very bad crime district. But it's overall for Georgia. Georgia has a lot of murders.
Person of another, I apologize. So, a crime involving the person of another. The aggravated assault charges is a crime involving...
I mean, that's how it is in Lancaster. So we have the suburbs surrounding the city, and then I guess there's a bunch of wards in the city. But as soon as you cross King Street, if you're going down Prince Street, as soon as you cross King Street, it's a whole different world, and that's one street. That's the ward. Even though there's multiple wards, that is the ward. And I mean, it spreads out. But yes, see, that's the word. But it's not like if I walked, it's 2 a.m. and I cross King Street and I'm just walking down the street. I'm not terrified for my life in Lancaster. I'm not. I mean, it would be a stupid thing to do for any woman to go out at 2 a.m. anywhere. But I'm not scared to walk around in the ward at 2 a.m. I even DoorDash sometimes at 2 a.m. when I need a little extra money to the ward. Georgia. I would not suggest it. I just would not suggest it. Even Reading, I wouldn't be too terribly scared in Reading. In Columbia, I wouldn't be too terribly scared anywhere around here of walking around 2 a.m. Georgia, on the other hand. Hell no. No way.
Involving the person of another because Napoleon was shooting at them. So, count 9, Napoleon had within arm's reach a handgun when he committed the offense of murder, which the judge is going to instruct you is a felony. There's that possession of a firearm during the commission of the murder against Jim Johnson. Count number 10, Napoleon had within arm's reach of his person a handgun when he committed the offense of aggravated assault against Jim Johnson by shooting at him. Count 11, he had within arm's reach of his person a firearm when he committed aggravated assault against Tanya Driver. Count 12, he had the firearm within arm's reach when he committed aggravated assault against Jermaine Deckard. And lastly, count number 13, he committed this offense when he had within arm's reach a handgun during the commission of aggravated assault against Xavier Young, who was in the house. Now let's talk a
People
little
need
bit
their Big
about
Macs,
self-defense.
even at
What
2
is
a.m.
Self-defense. Self-defense is, there's several different things about it that I'm going to talk
Don't go out
about.
walking
So,
in Georgia. Stay safe in your house with your kitties.
The state has to disprove self-defense beyond a reasonable doubt. That burden is on us. So, the state must prove beyond a reasonable doubt that the defendant's actions were not justified. A defendant is justified in using force that is intended to or likely to cause death or serious bodily injury when that person reasonably believes that the use of such force is necessary to prevent the death or serious bodily injury to himself or a third person.
Georgia. We're in Dodge County, Georgia.
Self-defense is not justified. Self-defense is not justified when you provoke the threat or use of force against himself, intending to use that.
Yo, that seems like a loophole there for a lot of murder. Self-defense is not justified if you provoke the attack. Every single person that kills another person is gonna, not every single, you know what I mean. Most people who killed another person said they were provoked into doing it. So that's sort of, like, they could be a little more specific about that. No matter what words I say to you, you should not be allowed to kill me because I say words. That words should not be able to provoke you into killing me. Now, if I, wait a second. I hear you because they said with words, I'm going to go get a gun. But then they went into the house and they stayed there and then they came out of the house. So a normal person would believe that if I'm in a fight with someone and they say they're about to go get a shotgun and then they go and then they start to come back, there is a strong probability they have a shotgun. So the words didn't provoke him to shoot. I say it was the actions after the words, but that's just me. If you provoke someone, they can murder you. That feels a bit vague to me.
Threat or use of force, and it's as an excuse to harm the person. So you can't provoke them and then say you're acting in self-defense and use that as an excuse to harm. It's also not justified when the person is committing a felony. It's also not justified if the person is the initial aggressor unless he withdraws from that encounter and communicates that to the other person. It's also not justified if you are engaged by combat or agreement unless that person withdraws. And if you are worried about this, don't worry about it because the judge is going to instruct you. You'll get to hear it one more time. Now, self-defense.
Kelly, stay indoors.
For the defendant he must believe that that threat or use of force is necessary. That belief must be reasonable, which means a reasonable person would also believe that the threat or use of force is necessary. And then the defendant's reasonable belief must be what prompts him to end up using that force. Now let's also talk about excessive force, and the defense brought this up a while ago as well. So a defendant is not justified in using excessive force while acting in self-defense or defense of others. And if you decide that the defendant used more force than what was reasonably necessary to defend against the victim's threats or use of force, he's not going to be justified. This is where we're getting at the 13 shots. So let's talk about what self-defense is not and apply it to this case. Self-defense is not shooting 13 times, shoot until he ran out of bullets. Self-defense is not stepping away from the carport and into the grass toward Jim Johnson. Self-defense is not shooting at an unarmed man. It is not shooting Jim Johnson as he was turning his back. Self-defense is not shooting Jim Johnson as he was running back into the house. And self-defense is not continuing to shoot where once Jim Johnson was back inside the house. And you know from Napoleon's interview that Napoleon told you after Jim had already made it back around, got in the house, he wasn't even outside for the last couple of shots. It's not self-defense. Remember, again, no one sees Jim Johnson with a gun but Napoleon, the man who shot and killed him. So we are nearing the end of my closing argument.
Guilty.
And I just want to go ahead and thank you for your time and attention today.
Looks like I overlaid that on this video, but I didn't. I'm not that creative.
We will not be able to resolve cases without you and your attention serving as jurors. And I know it's been a very long week. I know everybody is tired, but you all have been very, very...
When she says it's been a very long week, she was just talking about the defense attorney's closing statement.
attention. You have fulfilled your duty as jurors to the fullest extent. And we just want, on behalf of the state, to thank you for being here. Thank you for listening to us.
Monica, that's a bunch of BS, too. The purge, once a year, baby. That's what we need.
I told you that I would come back one last time, and here I am. And I submit to you that the state has proved each and every charge listed in the indictment beyond a reasonable doubt with the evidence that we presented at trial this week. And here I am, like I told you I would be, and I'm going to ask you now to find Napoleon Flowers guilty of each and every count alleged in the indictment. Thank you for listening to me today.
All right, ladies and gentlemen of the jury, it's 3:15. As I told you, the charge is gonna probably take 30 minutes, well, it's gonna be more than 30 minutes.
Oh, no, it won't.
Take
No, it won't.
about a 15-minute break, and we'll start back about 3:30, okay? All rise for the jury.
I really, truly love this
I'm
judge.
gonna ask the spectators to once again stay in the courtroom until I exit in the back, and then y'all, when the bailiffs say y'all can leave, y'all can take a break also.
You gotta wait till you get out.
There's more spectators now. I wonder if both families are here. The judge says thank you for your brevity. Okay. I don't think anything else happens on this person, on this one. So they're talking, but it's completely muted. We don't take kindly to jury instructions in these parts. Completely muted. There's nothing here. So, I'm going to show you the heart
I know
attack.
that you have a monitor in front of you, and you have this other device that may be blind
Oh, that
as well.
sucks.
But,
I
you can,
can't tell you how much that sucks right now. If you could just talk amongst yourselves for a moment while I go and get the correct clip, because I marked the wrong one as verdict, and this is the wrong one. So yes, Hedwig, he's the one we saw. Mr. Kelly, don't you point your finger at me, Mr. Kelly. But she didn't do it. Why do I have to prove myself? I played him a couple times. I played this judge a bunch. But Mr. Kelly is the biggest star of the judges' dockets. But I got the wrong clip. So if you guys could just guess on what the verdict is going to be for a few minutes, I'll go get the verdict. You know what, guys? I'm going to do something while we're waiting. So it says it's going to take 5 minutes. What a coincidence. Jude made 2 songs. I'm going to play them. I don't care. I don't care. So here's what happened. Here's what happened. If you missed the stream where I was talking about it, there's a neighbor across the street that I got into a bit of a spat with because she said something to my daughter. She said her truck was ugly and she wasn't allowed to park it in front of her house. So I had words with her. I'm gonna play these songs while that's going on. Can you hear this? Okay, now I have to wait like 10 more seconds because there's a delay. I just need to know if you can hear that. You could? Get out of here. I don't even have my desktop audio on. They're not polished up. They're great. Yes, I see, but I didn't get to listen to it. So I'm only going to play 2 songs. Here we go. Actually, I'm going to do something sketchy, but it'll be okay. It'll be fine.
What do I see when I open my door? Your truck sitting out like it's been there before. Didn't I tell you to move it off my lawn? One more day and that ugly thing's gone.
Thank you,
But I
Kelly.
clicked play, I ran out the door. Had a daughter to drive and errands galore. Still I got a room nights that the chatter's quiet as a mouse, worried Kathy might get hauled from her house. They love their boss but fear the law. Nobody wants to post free Kathy at all. A hat was passed, a coin was tossed. We can't go on if our leader's lost. But right when they thought she was gone for good, she marched back in like a queen oughta would. Hey, Kathy's back. Praise be above. The coffee in hand is still full of love. The neighborhood's shaking, that lady's apart. But the chat room cheered like she'd won a bar brawl. You don't mess with Kathy, or she'll mess with y'all.
Now there's a part 2. This is the one I listened to first for some reason. I clicked part 2 first. I don't know why. I think it was because of the picture. And this is, it's just.
Now gather round, neighbors and misfits alike, for this here's the tale of one brave woman who dared to speak the truth with a coffee mug raised high. Some say she went too far, but the people say she didn't go far enough. And so the legend begins. They hauled her off in handcuffs, no warnings, no delay. Sheriff said, ma'am, that tone of yours ain't lawful in this state. That mean old lady stood there smirking, dog tucked under her arm, while Kathy just sipped her coffee, saying, go on then do me harm. Free Kathy! Free Kathy! She didn't start no war, she just told the truth out loud. Free Kathy! Free Kathy! You can't jail justice, the people won't allow. They locked her in the cruiser, blue lights flashing bright. That old lady let out a cackle, thinking she'd won the fight. But little did she know, across the neighborhood streets, a mighty force was rising up, led by worn-out folding seats. Some brought posters, some brought pie, one brought jumper cables just in case someone yelled to the precinct, and off they marched in grace. Even the Roomba tumbleweed rolled in cactus still taped on top. They formed a picket line and shouted so loud the sheriff told them stop. Free Kathy! Free Kathy! She fought for every neighbor with a mug held strong. Free Kathy! Free Kathy! You can cuff her wrist, but you can't cuff what's right from wrong. Sheriff, finish your paperwork. I'll be back online in 10.
So I did. I listened to the first one, the second one first, and I was dying. I was crying. I was laughing so hard, Jude, because because my mouth did get me in trouble. I said to my mods in chat the other day, don't no one shoot off at the mouth, and boom. Now I landed myself in a whole world of trouble for that one comment. And then if I would have played that one first, oh my gosh, if you only knew how much I was laughing when I heard that first one. It was beautiful. Okay. It's ready. I just gotta get it. I got distracted. I do that. Here we go. Now I'm gonna tell you, I was sending text messages to this judge's stream, literally begging him this day, because if you press play which it's already playing. Look, you can see people moving around. The judge has everything muted. And I was just like, oh, Judge, please. Caps, exclamation points. Judge, please. Please, Judge. Please unmute. Judge, there's no sound. And it goes on. Don't worry about that. Still, the lawyers are talking. It's muted. And, I'm like, oh no, I need to get this verdict. I didn't even know the verdict was going to be excellent. I had no idea the verdict was going to be excellent. But it is. I don't know when he's unmute, so we're going to figure it out. It's not now. It's been an hour and 40 minutes. Hold on. I think he unmutes shortly. I'm going to bump it a little bit. Nope, he's still muted, and I am.
And Mr. Ruffin, have y'all,
Okay, now the jury's coming in. Here we go.
Mr. Jones, you don't have to enter the jury box if I just want you present, okay? Is that all right with the state,
It is.
Mr. Smith?
It is, Your Honor.
Mr. Brantley, if you'll just, all right. All right, let's all be seated. All right, who's the foreperson of the jury? Mr. Ruffin?
Yes, sir.
All right. And Mr. Ruffin, have y'all reached a verdict in this case?
Yes, sir, we have.
All right. Was it unanimous?
Yes, sir, it was.
And has the verdict been filled in, signed, and dated by you?
Yes, sir, it has.
And if you'll be kind enough to, well, technically you're supposed to stand, so
Yes, sir, I
stand
will.
for
No-
me,
no
okay? Have you reached a verdict?
Yes, sir.
Was it unanimous?
Yes, sir.
Has the verdict been filled in, signed, and dated by you?
Yes, sir, it has.
If you'll please hand the verdict to the bailiff, and you can have a seat now.
The judge already understands it's bad. It's really bad.
All right, if counsel will approach, please. I'll let y'all look at it, and then
Then you'll what? What, Judge? What? I don't think neither of them understand right now. They do, but not yet. I think the judge knew instantly this was bad. He muted it, and I don't know how long it's muted. I just don't know. Not muted anymore.
any objection to to the form or the legality of the verdict from the state,
No, Your Honor.
Mr. Smith?
Trying to research the issue.
Well, I'm gonna ask that y'all go back. Let's all rise for the jury, please.
Jury, get out of here. Get out, jury. Just get out. Go hang your head, jury. You had one job.
Let's keep the alternates that they can go back in their room. All right, y'all can go back to council table.
Nothing is fast in Georgia, guys. Just relax. Just relax.
All right. I'll hear from the
You would never ask the jury to reconsider a verdict. That would be terrible to do. He's stuck with the verdict they gave him.
All right, I'll hear from the state if it has anything to say.
The state does not have any objection to the verdict. I don't believe that is against.
Hang on just a minute. Did they bring back, or are they still in the jury room? But go ahead. I'm sorry, Ms. Dillon.
I don't believe that it is clearly against the evidence or enter manifestly without evidence. I don't believe that it's conflicting. So the state would have no objection to it.
Well,
I didn't hear everything she said. I didn't. I don't know what she said. All I know is she does not object to the verdict. She's like, that sounds legit to me, Judge. Let's go. Let's just roll with it, Judge.
we don't have
They're not going to pull the jury. It's unanimous. They unanimously. Nope, not going to pull the jury.
term I'm looking for. Hang on a minute. We don't have inconsistent verdicts in Georgia.
No! No! Come on, don't! Guys, what happened? Inconsistent verdicts is when they have some charges guilty and some charges not guilty, but they don't make sense. For example, a guy walks up on Fifth Avenue and shoots another guy with a gun, and he is charged with murder and felony possession of a weapon. And he is found not guilty for felony possession of a weapon, but then found guilty of murder. So that doesn't make sense. He had to have had the gun to shoot someone. So they found this guy guilty on a few and not guilty on a few, and they don't make sense together. If he did A, he had to have done B. You can't do A without doing B first. So now now they got to figure out what to do. They can't tell the jury, you got it wrong, fix it. That was their verdict.
It appears that the jury has found Mr. Flowers not guilty as to all counts that relate to Jim Johnson. And well, let me.
He can't even talk because he doesn't know what to do.
What was? Oh, they've got the indictment and the. Let me look at something. No, the indictment's back with the jury.
I can print it if you want me to.
Huh?
I can print it if you want me to.
I can look it up.
Okay.
I wonder why they don't have inconsistent verdicts in Georgia. Like, they have to have a procedure for when something like this happens. I've never seen this happen. Never. I've seen guilty, not guilty, but never. I've seen guilty, not guilty. You know, I've seen counts not guilty while some are guilty, but never like this. Never. No, they can't give the jury instructions. That would be so illegal. They can't have the jury reconsider. So illegal.
All right.
Just so everybody understands, J.K. knew the answer back when the prosecution was given their closing arguments. J.K. said, he was found guilty for bullet 2, 4, 6, 8, blah, 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 but not for bullets 1, 3, 5. Good job, J.K.
They have found Mr. Flowers not guilty as to counts 1, 2, 3, and 4. And those all relate to the 2 murder counts, the assault account and the aggravated battery as to Mr. Jim Johnson.
Man, I'm going to show this judge again this week. Something from our past. And it's so good. You're going to see this judge lean forward to yell at someone this week.
Have found him guilty as to the ag assault in count 5 to Mr. Driver, count 6 as to Mr. Decker, and count 7 as to Xavier Young. And then they have found him guilty as to count 8 cruelty to children in the first degree. Then they have found him not guilty in count 9 as to possession of a firearm during the commission of a felony, and that related to Jim Johnson. And then count 10 they found him not guilty. Possession of a firearm during the commission of a felony. And that related to Mr. Johnson. And then count 11, 12, and 13, they found him guilty, and 11 relates to Ms. Driver, 12 relates to Decker, and 13 relates to Mr. Young, or
So what the jury just said is, yes, he shot at Mrs. Driver, or Miss Driver, I don't know if she's a Mrs., and grazed her foot. Yes, he shot at the house that contained a 15-year-old. He's guilty to cruelty to children. Yes, he shot at that other dude. Shot right at him. Yes, he had a gun. Yep, he did. Nope, he didn't shoot Jim Johnson and kill him. Jim Johnson fell down on his own accord, I guess.
so the question and the verdict, what's your posture, Mr. Smith?
Your Honor, again, was trying to look up the issue as soon as we received note 2. As soon as we received note 2, I was trying to look up this very issue. Because if they have found my client not guilty of counts 1, 2, 3, 4, 9, and 10, then there is a finding of self-defense and justification. And if they found the self-defense and justification in firing at the back at the individual that was exerting, then that would also follow that 5, 6, 7, 8, 11, 12, and 13 should also be found not guilty under self-defense and justification because of the initial perpetrator being, in this sense, because he's found not guilty, Jim Johnson. And so I was looking for case law on, because as the court stated, we don't have case law that says that inconsistencies would be grounds.
I mean, the way I understand the law, we don't really call it, I've got to accept a verdict that's inconsistent, but I don't have to accept one that's mutually exclusive. And the issue is this a mutually exclusive verdict? If it is, then I've got to send it back and they continue to deliberate.
And I would need to, honestly, to research that issue, Your Honor.
Yeah, I understand, but I got a jury that's 6:30, 25 minutes to 7.
Well, Your Honor, I mean, well, obviously, our position would be that they need to deliberate that issue regarding counts 5, 6, 7, 8, 11, 12, 13, because if they find,
So I tell them they need to deliberate when they've reached the verdict.
that's my dilemma of trying to research that, the mutual exclusion. I was looking at repugnancy as part of these issues, but procedurally, dishonestly, I have not come across this procedurally of how to be able to handle that situation.
Ms. Stan?
I would say that just because the jury may have found self-defense as to 1, 2, 3, 4, 9, and 10, which are the counts relating to Jim Johnson.
Yeah, but the problem is that if they found, and I'm just talking out loud, that he had the right to fire the gun, then how can he be found guilty because there were other individuals involved?
Because there were 13 separate shots fired, and they could have found that the shot and the one bullet that killed Jim Johnson was justified, but not the 12 other shots. So it wouldn't be
You
mutually
got some law
exclusive.
to that effect?
That's a good
I'm sorry?
argument.
You got some law to that effect?
I'm looking for some now. I have come across a case that is talking about an issue like this. That's 290 Georgia 172. I haven't got to read the whole thing, but it is similar with a self-defense.
You got your laptop, Marlon? Yeah.
Hi, Walter.
Always a first.
I liked her argument. I thought that made sense. Judge wants law to back it up, though. Hey, Linus. Hey, Linus. Oh my gosh, hey, Linus.
Miss Stanley, if you'd be kind enough to give the court that site again, please.
290 Georgia 172.
Thank you. Giardro or something to that effect.
Yes.
Come on, Judge. Judge, do something. Unless they were running towards a gun to shoot you. He muted the jury instructions. Yes, listen, we called Judge Ponder. He ain't got nothing on this judge. This judge can ponder. This judge ponders in the middle of sentences. No, if they turn around to run and get a gun, like there's a gun behind me, if I turn away from you to run to get the gun, then you can shoot me in the back. That's self-defense. Because I was running to get a gun to shoot you. I don't have a gun, so I can't shoot you. If I had a gun, I'd be in jail. I like Jude can give verdict way better, Jude. That's better than judge can give verdict. Judge needs laws to back it up. Yeah, the judge can override it, but then it'll be appealed. And then they'll win that appeal. I don't think it matters what happens now. It's getting appealed, and they're gonna win an appeal if that's what happens. I can't tell you what happens. We're gonna get there in a second, though. It is so confusing. I've never seen this. They're all trying their hardest to find cases. The lawyers are moving very fast right now. The judge, he's still on that first case. He's reading every word. Another month or two and I'm going to need to find my coat, Zach.
see that charge. Let me see that charge. That right there, the whole thing, yeah. Thank you. Here's what I'm thinking. Before we officially publish the verdict, and I accept it, do we let this jury go home for the day and
I was
have them
screaming
come
no.
back in the morning and then make a determination of whether or not the verdict can be accepted? Ms. Stanley? And I'm just asking. I just hate to keep them here while we're figuring out. And I hear you and I see what you're saying. You know. But the problem is that I don't know that the charge was specific as whether or not Mr. Flowers could be found guilty of, well, let me say it this way, that the concept of self-defense applied to all of the counts. Well, think the state's got a valid argument.
I, of course, will have to reiterate that I think that we do have a valid verdict, at this time,
Well, I understand that,
but
you know, once I accepted and released the jury, if you're incorrect, then, that means we're gonna have to do it all over again.
I understand.
Mr. Smith?
Your Honor, I would want to release them for the evening. I think I said it a little earlier, that was my angst when we got that second
I
note.
understand, but the situation is different.
Yeah. And I would like to be able to have the opportunity to be able to research that issue, and I can do that overnight before we publish the findings by the jury.
Well, Mr. Stanley, I don't see how the state is gonna be prejudiced by that.
Well, no, I don't believe that I'm prejudiced by that, but, I mean, if we need to brief the issues,
No, I mean, we just have them come back in the morning and I'm not saying one way or the other what the court's gonna do, but if I've got a jury that's already heard it, and if you're incorrect, then I can tell them they gotta go back and deliberate some more.
I understand.
And that seems like, to me, the most practical way to handle the matter. Because if the state's not correct, then we would have to do it all over again.
The state, is aware of that and does understand that. We can brief the issue if that would be preferred and come back tomorrow. I'm not objecting to doing that.
Well, I think that's probably the most practical thing to do. What do we tell this jury? They think they've got a verdict.
I think we could just tell them that there has been, a matter brought up by the parties that needs to be discussed without getting anything specific, and that they are to return tomorrow.
And Mr. Smith says,
I concur with that, Your Honor, to give them something that is neutral, just like any other time when we are taking matters up outside their presence.
all right, what I suggest I do, or my suggestion is gonna be, I'll call them back in, including the alternates. Tell them that they'll need to return in the morning because,
No, they wouldn't have come back in for sentences. They were done.
Yes, Your Honor.
state good with that,
I am.
Mr. Smith?
I am, Your Honor.
All right, so all rise, Marlon, if you'll tell the bailiff to. All right.
cases that I came across is the same case that the state cited.
All right,
Okay, this is the next morning. They all came back in, and now they're going to tell the judge what they think they should do.
Madam Court Reporter, do you have note numbers?
They did bring the notes out to me.
All right. Mr. King, will you ask the bailiff to, I need the notes.
Be right back.
Of course, the notes were read into the record so we could. Mr. Davis, what I'm looking for is the notes that the jury sent to the court. You can bring the pads in, but what I'm looking for is the notes
Okay,
that, and they were to save those.
okay, all right.
I'm back. Are they waiting for the jury to come back in? I missed it. But Japanese cherry blossom from Bath and Body smells really good. What are we waiting on? Should I fast forward it?
But what I'm looking for and what I need is the jury had sent me two notes in. And
You need them.
that's what I'm looking for.
They're back there in your office, the 2 notes.
Are they in the box?
If they're in the box is in my office.
They got the box right there.
No idea, JK. I got more to say to you, JK, but not yet. Not yet.
I had instructed that the notes needed to be saved.
Well, I don't see them in there, Judge.
Well, let's ask the other bailiff to ask the
Sanctions.
foreperson if he knows. those notes.
Sanctions. Nope, nope, nope. It's a kudos. I think he wakes up a little pissed. I think he's always hungry. The next trial I show you guys from him, it's going to be one day. It's a divorce, and it's going to be on Thursday. Because after my double on Wednesday, I'm not going to be able to function before my stream to find content. So I know it's going to be Thursday. Thursday's going to be the next one, and it's fantastic. It's just so good from beginning to end, except the audio. I'm going to bump the audio up as much as I possibly can, but you won't be able to hear the lawyer at all times. You'll hear her, just not at all times.
The limited amount of time that we've had,
Go ahead, Mr. Smith.
thank you, Your Honor. The limited amount of time that we've had, on the issue.
Is it free?
Try to research a number of cases. I did not find a case, even the state's cases that were cited. I did not find all of the facts analogous. I do know that in the McElrath versus state case, 308 Georgia 104, that's a Supreme Court case 2020. It goes through an analysis of the 3 different types of contradictory verdicts, that being inconsistent verdicts, mutually exclusive verdicts, and repugnant verdicts. Most of the mutually exclusive verdicts, the cases that I was looking at, it would be one same name victim, and it may be a situation of malice murder, felony murder, and he did fine, for the malice. And the case in which, the one case that I did locate, which is the same case that the state, cited, in their brief, that where there was a decedent and then other individuals that was inside of that car, there was some other verbiage that went along, and the court went through, pretty much a longer analysis of what those facts were in that case. In that case, you had the defendant who was making verbal statements such as, you know, I got you now, and things of that nature when firing, even though there was an exchange of gunfire at some point. And in that case, I think it was clear that, at least to me, that in returning fire, that individual could have exceeded any type of authority that he would have. In this situation, the facts are different from that. There isn't any language that goes along with this. There isn't a break, a gap in time from the firing. And from the note itself says, if we think it's self-defense, does that get rid of all of the charges? Or can we still keep assault against Tanya Jermaine Xavier, but get rid of all the charges against Jim Johnson? I wanted to look at the note specifically to see what the exact language of that second clause was inside of the note, because clearly they believed that there was self-defense. The state's theory in the case was that there was no firearm that was being held by Jim Johnson. And obviously the jury has found that, no, he did have a firearm. My client was legally justified in being able to return fire. Now, well, I still have the proposition that in him returning fire, that the finding of self-defense in him returning fire would cover all of the counts inside of the indictment. I just honestly have not found case law that, or at least right now, that goes to that specific point. Everything that I have right now is distinguished. There is case law that talks about if it's repugnant, as well as if it was mutually exclusive, that the court had the ability to not accept the verdict, to be able to ask him to go back in and deliberate. That's doing that before the verdict is actually entered into the court. And
New day, no mic.
what,
He turned it off.
at that point. And in at least one of the cases that was cited, the jury actually came back with a different verdict. Given the time that we have, Your Honor, and at least for purposes of the record, we're asking that the court find that it is a situation where this is repugnant, that logically, if there's self-defense that is here for the individual who began the shooting, which caused my client to be able to return fire, that any aggravated assault as a result of my client returning fire is also subject to the self-defense. And so we would ask that the court not accept the verdict, to request that the jury go back and further deliberate, but reread the charges to the jurors, if not all of the charges, at least the charges that relate to self-defense, which is charges 28 through 33.
Okay. I mean, when I say okay, are you
No,
through?
I'm
I mean,
finished.
you know, okay. All right. Before the court had left last evening, but after we had recess for the day, the court had found the case, Giardio versus the state 290, Georgia 172, which is cited in the state's memo to the court. Court found that case quite persuasive. In that case, the defendant was convicted of felony murder, 3 counts of aggravated assault, and 3 counts of possession of a firearm during the commission of a crime. During that, in that case, the jury sent out a note inquiring as to whether, quote, it would be possible to find defendant not guilty on count 1, the malice murder, due to self-defense, but find guilty on all other counts. And there was a verdict to that effect, and it was sustained on appeal, and it was determined by the Georgia Supreme Court that such was not an inconsistent verdict, nor was it mutually exclusive or repugnant. I found that case to be, though not on all fours, but would substantiate the posture that we're in here, especially in the light of the fact that that was a one defendant case and, a one victim case, and self-defense just went to 1 count and not to all other counts. Here we've got numerous victims, specifically 3 other victims, and so the concept that self-defense potentially could not apply to them is within the law. And so the court is going to accept the jury's verdict in this matter as a valid verdict, finds that it's not repugnant nor mutually exclusive, and the court's not going to allow any further deliberations in this matter. What I intend to do, if you feel the state, I assume, has no objection as to the form or the legality of the verdict at this point. Is that, you want to state for the record, Mr. Smith, and even though you already have received my ruling, of course, yesterday but go ahead.
Your Honor, just for purposes of the record, we do object to the court accepting the verdict as tendered for the reasons that were just stated on today as well as on yesterday.
Okay, very good. And the court notes your objection and your exception, and the ruling that it had previously stated will stand. What I'm going to do is bring the jury back in. We will then publish the verdict. I'll ask that Mr. Smith and Mr. Flowers stand at that juncture, and then after it is published, I will inquire as to whether or not the jury needs to be polled. Once again, I caution the spectators in the courtroom, if there is any emotion showed whatsoever while the verdict is being published or after the verdict is published, the court will deal with it appropriately. The court is not going to allow any reaction to the verdict in this courtroom. Anything else the state wishes the court to do at this juncture? No, Mr. Smith? Very good. Let's all rise for the jury. When they come in, we'll do the pledge, and then we will go forward.
Fast forward a bit because we are over our time already.
Defendant guilty of aggravated.
Could I give you the budget back? Oh, here it is. All right. I will ask that Mr. Smith and his client stand for the publishing of the verdict. Then I will ask the clerk to publish the verdict.
You ready to go forward now?
Yes.
In the case of State of Georgia versus Napoleon Flowers, case number 23R 2964, the verdict reads as follows. We, the jury, count one, we, the jury, find the defendant not guilty of malice murder. Count two, we, the jury, find the defendant not guilty of felony murder. Count three, we, the jury, find the defendant guilty of aggravated assault.
There's more. Hold on, guys.
Count four, we, the jury, find the defendant not guilty of aggravated battery. Count five, we, the jury, find the defendant guilty of aggravated assault. Count six, we, the jury, find the defendant guilty of aggravated assault. Count seven, we, the jury, find the defendant guilty of aggravated assault. Count eight, we, the jury, find the defendant guilty of cruelty to children in the first degree. Count nine, we, the jury, find the defendant not guilty of possession of a firearm during the commission of a felony. Count 10, we, the jury, find the defendant not guilty of possession of a firearm during the commission of a felony. Count 11, we, the jury, find the defendant guilty of a firearm during the commission of a felony. Count 12, we, the jury, find the defendant guilty of possession of a firearm during the commission of a felony. Count 13, we, the jury, find the defendant guilty of possession of a firearm during the commission of a felony. It's on the 9th day of October 2025, signed Michael Ruffin, jury foreman.
Thank you very much. Mr. Smith, do you wish to have the jury polled?
I do, Your Honor.
All right, clerk, if you got a jury list. Ladies and gentlemen,
It was
as
unanimous.
your name is called, thank you very much, Ms. Jones.
Brittany Lee.
Ms. Lee, was that your verdict? Is it still your verdict?
Yes, sir.
You said yes, sir? Y'all can be seated. Ms. Stanley?
Judge, at this juncture, it seems that they do not have a unanimous verdict.
You agree with that, Mr. Smith?
I do, Your Honor.
What does the state wish for me to do?
I did not know that. One of the jury's people changed their minds. Ah!
I think at this point, the jury would have to reconvene and continue deliberations until they have a unanimous verdict.
She asked for redeliberation.
Your Honor, I ask for the case to be declared as a mistrial.
Based on what?
Well, at this point, Your Honor, I'm looking at the note that was tendered, and without
He asked for mistrial.
obviously being able to question the juror. If there is a disagreement as to what the should be. And she has already stated that she does not agree with the plea verdict. Then we're at a situation of whether there's an impasse where continued deliberations is going to be fruitful or not.
Well, I don't see where we have any reflection that there's an impasse. We obviously we received a verdict, last evening, and this morning, we have one, juror saying that it is not her verdict. We don't know whether, that applies to numerous jurors or just this one. But at the juncture, I stopped because of the fact that we don't have a unanimous verdict at least as to one. So I'm just asking you, how can I discern that that they're at an impasse?
And I understand that, Your Honor, just from the passage of time, they haven't deliberated in the grand scheme of things for.
Not long at all.
Correct, Your Honor.
About an hour, maybe an hour and a half. All right. Anything further?
I am still at the point of wanting to have them recharged.
Well, I'm going to instruct the bailiffs to take the indictment, the evidence, their notes, the verdict form, back to the jury room and tell them to begin their deliberations again. Where are the two alternates at? They back, okay. All right, let's make sure we got everything, that needs to go back. Ms. Stanley, you and Mr. Smith check, make sure.
Yes, we will.
This whole part I missed. I didn't know any of this happened. This whole part I never saw before. I must have recorded it while I was work. I know. All right, they're going to let the jury go back offline. Now they're back.
Not been deliberated very long at all.
They didn't deliberate very long at all.
But if they are saying that, which the note said everyone is 100% positive,
Everyone is 100% positive that they're not going to change.
coerce someone, it sounds like they are locked.
It sounds like they are locked.
So at this point, I think it would be a mistrial.
Like JK said hours ago. I know a bunch of you did too, but JK said it
Smith.
way before.
Again, with ask for it to be declared a mistrial. I did just go back to having charges 1.70.74 on the jury. Whether you reading that would be applicable. Inside of that, it does say in the first sentence that you
AI channels are the worst. I am not AI. Wake up, Judge. Wakey, wakey. If this were AI channel, you would never see this judge, because this judge, he's not just sitting there on YouTube waiting to be recorded. You got to find this judge, and he is in the weirdest place. He's not the weirdest place. There's one courtroom I get that's on a back low, like if you go to this radio station site, you have to click a whole bunch of links until you can get to this courtroom. I don't know why this courtroom, I'm not going to tell you which courtroom it is, but I don't know why they play it on a radio station site, but they do. And there's no way AI could do that. And there's no way AI could find this guy, because this guy's in a pretty weird place too. He streams in a pretty weird place. Not on YouTube. BI, hello. So yeah, we get to watch these painfully bad audios because they're not YouTube judges. Exclusive to here. And one other baby channel. Judge, I don't mean to rush you, but I gotta start OJ. I gotta go to work today, so. I'm about to just tell y'all what he says, but I'm not going to.
All right. As I understand the posture of the matter is the state wishes the court to declare a mistrial. Is that correct?
Yes, Your Honor.
And Mr. Smith, on behalf of Mr. Flowers, you consent to that motion?
I do, Your Honor.
All right. That's what we'll do. Neither of you wish for me to give the Allen charge.
No, Your Honor. Again,
I mean, the note's pretty clear that they're deadlocked. All right, based on the fact the state and the defense consent to a mistrial, I will declare it a mistrial. All right.
That's what happened, guys. That's what happened in this murder trial. That's crazy. That was a crazy one. So they're going to have to start all over at the beginning. No, he does not get to go home today. I'm pretty sure. Hold on.
Let's get the jury to come in.
I'm pretty sure we're not gonna watch. I'm positive the bailiff takes him out.
The jury courthouse property.
There's only 13 seconds left. Oh, with this timer, it stinks. It doesn't count down. It just refreshes every once in a while. He turned his feed off. He turned the feed off there. That's all we got. But anyway, they're going to do it all over again. And nope. If I see it, I might get the verdict. Just so that we have closure ourselves. But no, I'm not getting that whole trial again. I'm not. I didn't get the whole trial the first time. I didn't. I got what we needed, which was a lot. Like, we really didn't need his whole closing statement. That could have been summarized in one PowerPoint. Two PowerPoints. Self, defense. That's it. Done. And then the prosecution is even easier. One PowerPoint. Guilty. I'm going to start OJ now. I hope you guys have a great day. Jude and Kelly, thanks for the songs. I appreciate it. All right. Have a good day, guys. I'll see you all later. Thank you so much for coming out. Thank you. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.